we're going to talk about estate planning. And we picked this as the first one because with the whole COVID-19 thing, I've had a couple close friends pass away in the last couple months, one from COVID, and we've had some clients, parents pass away. And so we've seen the impact of what having or not having estate planning does to people, and it's a major concern. So we wanted to make sure that we're getting the information out there about how estate planning works. And so we're going to go through kind of how estate planning and probate and taxes all work. Then we'll talk about the documents you need, the why and how of the documents, and then we'll talk about some of the issues we see, and then also some smart plan ideas, and then we'll open up for questions. So, we kind of titled this, "What Happens to Your Money When You Die?" So that's kind of where we're going to start. So you can see this funnel here, where essentially that's your estate. Everything you own goes into this funnel, and they'll pass a bunch of different ways, and we're going to talk a lot about how assets pass at death. But they go into the funnel, and that's your estate. And from there, your debts have to be paid, your credit card debt, your mortgage, your car loans, all of that kind of stuff. You could have estate expenses. That could be probate. It could be paying an executor. It could be doing valuations. And then taxes have to be paid on some of the assets. And either the estate pays the tax, or your beneficiaries pay the tax, or you pay the tax with a final return. We'll talk about all of that. So once all of those liabilities and debts are taken out, whatever's left's going to pass down to whomever you intended to pass to. And it can be distributed in a bunch of different ways, via beneficiary designation. It could be via a living or irrevocable trust. It could pass through your will. It could pass title, like joint tenants with right of survivorship. And if you don't have any of these, then it passes by the intestate rules of the state. So we're going to talk some more detail about all of these ways that assets pass and the differences between them. So how assets are passed at death? Probably the biggest one is a beneficiary designation. For most people, your retirement plans, your IRAs, your 401ks, all of that kind of stuff is usually your biggest asset. And those pass via beneficiary designation, as do life insurance and annuities. So if you have any of these assets, you name a beneficiary for the account, you pass away, whoever the named beneficiary is going to receive those assets. And we'll talk a little bit later, but that beneficiary designation controls. And if it's not up to date or it's wrong, you could end up with someone getting these assets that you never intended to. The other one is title. If you own your home, it's typically, if you're a married couple, it's typically joint tenants with right of survivorship. So the first person passes away, it passes automatically to the second person. And then at the second person's death, then it's going to transfer via trust or will or whatever we have. So a lot of bank accounts are joint tenants with right of survivorship. And then you could have accounts like investment accounts or bank accounts that are what are called transfer on death, meaning that you name kind of a beneficiary, and at your death, those assets pass automatically, and so they don't go through the probate process or they don't transfer through your will. It's not as clean or smooth as a joint tenants with right of survivorship, but it kind of accomplishes the same thing. It's kind of like a cross between a beneficiary designation and a title. And then you have your will. So if assets aren't going to pass from beneficiary or through a titling, then they're going to go via your will, and they're going to go through probate. And so then the will is going to dictate who's going to get your funds. And we'll talk about more about how wills work. A will could also pass assets into a trust at death, what we call a testamentary trust. So we're not creating one while alive. You can create it at death via the will and put the assets in a testamentary trust. And then you have revocable and irrevocable trusts. And we'll talk about how these are different than a will in a little bit. But these are pretty common, particularly in California, that we use revocable trusts to pass assets. And then finally, the default is if you don't have any of the above, then you have what's called intestate, and the state decides who gets your money, and they have a formula. And so it could be that you've got a retirement plan with, with a beneficiary designation, you got life insurance with a beneficiary designation, you got a house with joint tenants, but then all your other stuff, if you don't have the will, then it's going to go through the intestate process. Or if you have the will is going to dictate where all your other stuff goes. So you can have a combination of all of these, and you typically do. So then let's talk about taxes at death. So there are two different types of taxes. One, pretty much everyone's going to have to pay, and the second one, hardly anyone has to pay anymore. So first, you've got income tax. And if you have retirement plans, IRAs, 401ks, things where they've given you a tax deduction up front and you haven't paid tax, they're going to collect that tax at death. It's what's called income in respect of a decedent. And we'll talk more about that in a second. Some assets get what's called a stepped-up cost basis at death. And so then when your heirs inherit those and they sell them, they don't have a tax. And I've got a couple of examples of these in a second. But then when you pass away, the taxes kind of get divided up into two components. It's what did you earn prior to dying? For example, let's say you die in the middle of the year and you work half the year, you're still going to have income taxes on your income for that year, and we'll have to file a final income tax return. And if you had withholding, there may be refunds, or you may have to pay some additional tax. And then everything that's earned after you pass away gets filed on the estate income tax return. So you could have interest from bank accounts or final, salary payments, things like that. Those get filed on the estate income tax return, what's called a 1041. So usually the year of death, you've got to file both of these tax returns. One for the estate, for the income earned after you die, and one for your personal return, where you're going to pay income tax on what you earned during the year. If you're a married couple, the year that you pass away, you get to file married filing jointly. And so it'll still be a joint return even if one of you have passed away. And then you have estate and inheritance taxes. And so this has been all over the place. When I started in the business in the mid 80s, the estate exemption was $600,000. And so a lot of people had to worry about estate tax, and we've seen a lot of documents that are outdated that still have all these estate tax provisions in them. But the exemption today for each individual is $11,580,000. So if you're a single person, and as long as you're worth less than that 11.6, you don't have to worry about the estate tax. If you're a married couple, if we do the planning right, you've got $23 million of exemption. So the bottom line is 99.99% of the country does not have to pay an estate tax. Now, states also impose inheritance taxes or estate taxes. The good news is in California, we don't have either. There is no inheritance tax in California. There is no estate tax. And so if you're below these thresholds, which the bulk of our clients are, we don't have to worry about estate tax planning. And so we don't have to factor all that into the drafting of your estate plan and your documents. But if you live in another state or you've got assets in other states, for example, I have clients in Washington, and Washington has a $2 million exemption. So even though you may not have to pay federal estate tax, depending on what you own in these other states, you may have to pay state estate tax. And so we have to factor that into the planning as well. So those are taxes. You have income tax, more than likely estate tax, probably not, but we always have to be aware of it to make sure we don't have any problems. So in terms of income taxes at death, retirement plans, as I mentioned, you have what's called IRD, or income in respect of a decedent. So the way that works is your beneficiary pays the income tax when they receive it. So the government's going to collect their money. They gave you a tax deduction going in on the 401k or the IRA. It's grown tax deferred. They're not going to get away without taxing that when you pass away. So you have what's called an IRD asset. So the beneficiary, when they cash out that IRA or 401k, gets to pay the income tax. There is no 10% penalty. So that's an exception. So let's say you pass away and your 45-year-old child receives your IRA They'll pay income tax when they take the money out, but they don't have to pay the 10% penalty because death is one of the exceptions. Now, if you're married and one of you passes away, your spouse can receive those retirement plans, and they can do a couple things. They can roll it to their own IRA and continue it on, or they could leave it in your name and just pay tax as they receive it. And we look at both, and a lot of it depends on the age when one of the spouses pass away and whether we're going to need the money and things like that. But we have a couple more options when it's a spouse who's inheriting a retirement plan. And then if you have a Roth IRA or a Roth 401k, those are non-taxable. They taxed you when you contributed, and so then they don't tax you again. So if your kids or grandkids inherit a Roth IRA, they can pull the money out and it'll be tax-free just like it would have been tax-free for you. And again, no 10% penalty. So that's the way retirement plans work. It also works that way for annuities. You can kind of think anything that they gave you a tax deduction or tax deferral on, they're going to collect their tax at death. But if you don't get a tax deduction or tax deferral, meaning the government's already collected their tax, then you get what's called a cost basis step up. And so when you die, the value of that asset gets increased to the value on the date of death. And so at that point, you would only pay tax on any growth after the date of death. And I got an example here for you. So let's say mom bought a house for $150,000, 20 years ago. It's now worth $750,000 when she dies, and she passes the house to the son. So the son's tax basis for tax purposes is now $750,000. So the way this typically works is you'd get a real estate agent or a couple agents, or use Zillow or a combination of those, and say, okay, what's the going comps for this house as of that date? And that's how we establish the cost basis. So let's say son hangs on to it, sells it a year later, and it's gone up to $825,000. He'd pay capital gains on the difference between the $750 and the $825 only. So he would have $75,000 of capital gains, but he wouldn't have tax on the $600,000 of gain that was built in when mom died. And it works this way for real estate. It works this way for stocks, for bonds, artwork, anything like that has appreciation. So a lot of assets get a stepped up cost basis at death, and we can avoid some taxes on the sale of those assets. Okay, so let's talk now about the estate planning documents. And we already kind of know this is how the assets are going to pass. This is going to be the tax treatment. So let's talk about the pros and cons of the estate planning documents. And the ones that I've asterisked here, every adult should have. So if you're 18 or older, you need to have these documents. And, they don't have to be fancy. They don't have to cost a lot of money. But every adult should have these three documents, and we'll talk about them in more detail. And again, at a minimum, it should be just a boilerplate one, something like that. But everybody needs to have them, and they don't have to be complicated. You don't have to spend a ton of money. So if you've got kids who are college age or recently married, encourage them to get these documents put into place. And if you don't have them, or if yours are outdated, obviously, we need to get together and get those documents in place. So everybody should have a will. Everybody should have a financial power of attorney, and everyone should have, it's called a bunch of different things, a healthcare directive, a living will, a healthcare power of attorney. But those documents are pretty much mandatory for every adult. And then depending on the situation, you may have a revocable living trust, or you may even have an irrevocable trust. And we'll talk about some of the pros and cons of those in a sec. So what does the will do? If you have minor children, it's where you name the guardian. Who do you want to take care of your kids if something happens to you? It also appoints the executor, the person that's going to pay all those final expenses, take care of the funeral arrangements, pay off the credit cards, handle the probate process, all of that kind of stuff. So the will says, who do you want to be the executor? And then it spells out asset distribution. So again, we talked about those assets that don't go through probate, like a beneficiary designation or titling. But if it doesn't fall into those categories, then it's going to go through the probate process. So that's what the will does, is all those assets that are going to be subject to probate. This spells out who's going to get them and when they're going to get them and all of that. If we use a living trust, then the will is what's called a pour-over will, and essentially just says, hey, whatever's not in the trust already just goes into the trust when we die, and then the trust kind of acts as the will and spells everything out. As I mentioned, every adult over the age of 18 should have a will. A will is not a big deal. It can be typed up and handwritten, but it needs to be witnessed by two impartial people. So it's not notarized. It has to have two impartial witnesses. But it can be handwritten. That's valid in California. So that's what you should have at a minimum. Or you can use a service like LegalZoom, or you can buy kind of a boilerplate will and fill in the blanks. The key is to make sure that it is witnessed and then it becomes valid. Okay, so what is the probate process? You probably heard or attended estate tax attorney seminars that talk about how awful probate is and stuff. So what it means is if you die, then your will is going to be probated. So your executor, whoever you've named, is going to file the documents with the county, whatever county you live in. And probate's usually done with an attorney. There are services that you can kind of do it yourself, and we're going through one of those right now. It hasn't been the easiest, but it's certainly more cost effective. And right now what we're running to with this particular client, his mother passed away in January. We just started the probate process, COVID hit, and San Diego probate courts have been closed. And he's not going to be able to do anything until October. So it's stalled. But he's doing it kind of with kind of these do-it-yourselfs where they help you fill all the paperwork and file it. If it's not a big estate, and again, if everything else is passing through your beneficiary designations, you have 401ks or you have title, joint title on the house, maybe it's not a lot left over. You can use what's called the small estate affidavit. And so it's streamlined. And that number in California is 166,000. So if all of the stuff that has to go through probate adds up to less than 166,000, it's more streamlined. It pretty much, the process is, it's usually your spouse. Your spouse is going to inherit everything. And, the probate process is streamlined and it's very easy to do. If the amount's larger than that, or there's going to be multiple people that assets are passing to, then you go through probate. And this is where you typically hear, you should have a living trust because of these probate fees. They're a little pricey in California. It's one of the reasons a lot of people use living trusts in California. I've given you an example here, $1 million probate estate. So that could be just a house, or it could be a house and a couple cars and some jewelry or things like that. The sliding scale on $1 million, you'd be paying $23,000 in probate costs, or about 2.3%. So it's not cheap. And that's the fee that you have to pay, and then you may also have to pay attorney fees or executor fees and things like that on top of it. So the will gets filed with the court, and then the executor gets what they call letters testamentary. And so then the executor uses these letters testamentary to file documents with the creditors, to file tax returns, and to start distributing the assets out. And then they typically help with some the non-probate stuff too, like filing life insurance claims and retirement plan claims and all of that. So the executor has a pretty big job to do, to make sure all the taxes get filed, to make sure all of the debts get paid, to make sure everything gets transferred out to who it's supposed to go to, and then they file a final report with the county and they close out the probate. So it's kind of a complicated process. It's not cheap, and it's a lot of work for the executor. Okay, so what happens if you die without a will? And I just witnessed this with one of my closest friends of 40 years. He had a stroke in just right before COVID hit, literally a couple weeks before. Had a procedure, didn't recover from it, and unfortunately passed away alone in his hospital room because nobody could visit him. He didn't have any family. All of his family had passed away. He had friends that were kind of his family, but he didn't have a will. He never got around to figuring out who he wanted to get his stuff. And so what happens is the state determines. And so they have what's called the intestate rules. And this is kind of a typical ordering system, is what it is in California. So if you're married and you don't have a will, it's going to go to your spouse. Or if you have kids, it's split between the spouse and kids. If you don't have a spouse, then it goes to your kids. If you don't have kids, it goes to your parents, and then to siblings or to other relatives. Or in my friend Bill's case, it goes to the state if he has no family members. So essentially, his car, his wine collection, his cash, his IRA, all of that stuff went to essentially the state of California because he had no relatives and he had no will, because he just didn't get around to dealing with it. He was going to attempt to do it in the hospital, and unfortunately, he didn't recover enough to get the job done. So that's dying without a will. The other option that you've probably heard of is to have a living trust. And so what a living trust does, it essentially acts as an alternative to a will and to the probate process. So what you do is you create this trust while you're alive, you put assets in the trust, and then when you pass away, the trust document dictates who's going to get your assets, when they're going to get them, how income will be distributed. And so you have a trustee, and we'll talk about the roles a little bit more. The trustee kind of serves in that executor role, and that they're going to distribute the assets out, and they're going to follow the rules of the trust. A trust can usually last 100 years. California has what's called a rule against perpetuity. So the trust can essentially last 100 years. So while you're alive, or if you're married while you and your spouse are alive, you can revoke or amend the trust at any time. That's why it's called a revocable living trust. So you can make changes to it. It's simply drafting up a Word document and getting it notarized. Not a big deal to do. But so that's kind of how a living trust works, is it's very much like the will, except it doesn't get probated. So the benefits, again, you don't have to go through the cost and the time of probating assets. There's also no requirement to distribute assets out immediately. With the will, it says, hey, my kids are going to get, this much, and my, brother or sister are going to get this much, and everything's pretty much distributed out immediately. With a living trust, there's no rule against having to take everything out immediately. Like I said, the trust can last 100 years in California. So you can leave money in the trust, and what that does is it protects from bad habits or bankruptcies or divorces of the beneficiaries. It also is, I think, very valuable when you're dealing with second marriages, or if you're dealing with, maybe you have kids that have special needs, things like that. So, your kids may be adults, and you may think they're financially responsible, and, you love them dearly, but you may not necessarily like who they're married to. And you'd be concerned that, say, hey, if I pass away and I, pass $1 million IRA or home to my son or daughter, and then a couple years later they get divorced, they could lose half of that money in that divorce. Where if it's in the trust, that can't happen. Or, maybe you've got 3 kids and one of them's not financially responsible. They've got spending problems, or bad credit, or, drug or alcohol issues, whatever. You can leave that money in that trust for that person, and it's protected while it's in the trust. So it gives you more control over the ultimate disposition of assets. In second marriage situations, you can provide for your spouse in the second marriage, but ultimately leave the money to your kids from your first marriage, things like that. So it has a lot of benefits mainly in protecting the money from some of these issues. Yes, does it avoid probate? Absolutely, and it saves you some costs. And it's flexible because it's easily amended or changed. Like I said, you want to say, okay, you know what? I don't want my kids to get it at 25 anymore. I want them to get it at 30. You type up a Word document amendment, you get it notarized, you attach it to your trust, and you're done. Also, I don't know that this is a big issue, but for some people, a living trust is not public. Where if you go through the probate process, That's public information, so people can find out what you owned and who it went to and all of that. You don't have that issue with a living trust. So what are the terms of the living trust? So first you have the person who creates the trust. They're called the grantor, the creator, the settler. It's the person who creates the trust. I typically use the term grantor. It's just what I've used throughout my career. So if we're talking about the grantors, that's the person that creates the trust. Then you name a trustee, and with a living trust, it's typically yourself and or your spouse while you're alive. And then when you pass away, you have a successor trustee step in. That could be kids, it could be another family member, it could be a bank or a trust company. It depends on who you want to have that responsibility and how long you want them to have it. If you pass away and your 90-year-old parents are the successor trustees, they may not be able to do that job for very long. So you typically have to have another successor trustee as well. And if the kids are very young, when something happens, you may want to have a bank or trust company handle this because they're essentially going to be around for forever. In the living trust, you also specify who the beneficiaries are. And you can have multiple levels of beneficiaries. You can have, kids as the primary beneficiaries. And then if something happens to them, their share can go down to their kids. And so they'd be a secondary beneficiary. You can have charity in there. You have a lot of flexibility in who your beneficiaries are going to be. Then you're going to spell out the powers of the trustee. And normally you give them broad powers, the ability to invest the assets, to buy and sell things, to make decisions on paying off debts, all of that kind of stuff. So you usually give them pretty broad powers. And then you typically, if you're a married couple, you're going to specify what happens at the first death. So does it all just go right to the surviving spouse, what we call the I love you trust? And in a lot of cases, that makes a ton of sense. But like I said, if it's maybe a second marriage, maybe at the first death, it's income to the surviving spouse for their life, plus they have access to principal if needed, but ultimately it's going to go down to the kids from the first marriage, things like that. Then the trust is going to dictate how income is distributed, because income and assets are treated differently. So you can say income will be distributed out each year. You can say income is going to be retained in the trust. You can say, income's distributed, but principal's retained at the discretion of the trustee. Again, you can do pretty much anything you want in terms of defining how the trust works. And then usually the biggie is these terms of asset distribution. What ages do you want your kids to receive this money and how much? Usually what we see is something like a third at 25, a third at 30, a third at 35. And again, you can adjust those, as you see that your kids are responsible or not responsible. That's pretty common. Sometimes it may be, the money's going to stay in for the life of the kid. The trustee can make distributions of income. The trustee can make distributions of principal as needed for what we call health, education, maintenance, and support. But we don't want to give them all this money because A, we don't want them to go spend it all, or B, we want to protect it from divorces or whatever. And then ultimately it could go down to secondary trustees like grandkids. You can have subtrusts where, some of it's held in trust for the grandkids. The other ones where maybe you don't have grandkids, it can be passed directly. You can have it at the trustee's discretion as to whether anything gets distributed. You can specify certain purposes, what we call incentive trusts. So we'll see this sometimes as like, we're not just going to give you all this money, but if you use it for certain purposes, for example, to buy a house or to start a business or to pay for college, the trustee can make distributions for those certain purposes, typically what we call incentive trusts. And then you can distribute certain assets. Very common to have a attachment that says, hey, I want, Brandon to get the jewelry. I want Lauren to get the china, or, someone's going to get the car or the golf clubs or the guns or whatever it is. So you typically can specify specific assets in here too, and you usually have a schedule where you'd list those. And again, it's very easy to change that by simply doing an amendment. So what do you put in a living trust? Normally, when you create the trust, you're going to put the title to your home in it. And so you do a deed transfer with the county, and you put your home in there. So the home is owned by the trust. If you've got other real estate like rental properties, those typically go in the trust. You can have your bank account titled in the trust. You can have a trust account for your individual investments. So all of those things you can title in the name of the trust. So then when you pass away, the will doesn't control it anymore. Probate doesn't control it. It's in the trust, and the trust document controls it. And typically the trust document says you're putting all of your personal property into the trust when you form it. So your boats, your cars, your jewelry, your art, your baseball card collection, whatever you have, that automatically goes in the trust. There's no titling on any of those assets usually. So they automatically go in the trust. And then maybe, depending on the type of business it is, you might put your business interests in a trust. What you don't put in there, you don't put your retirement plans. You can't transfer your IRA or your 401k. The beneficiary designation controls where that money is going to go. So you don't put that in the trust. The same with life insurance, the same with annuities. Sometimes the life insurance will go in an irrevocable trust if we have to worry about estate taxes, but that's pretty rare. So those assets are going to pass by beneficiary designation. And so what you may do is you may have them go into the trust at death. The trust may be the beneficiary, and so those assets would flow in, and then the trust document would control when the money goes out and to whom. But you're not going to put those in the trust. It's these other assets that go into the trust. And that's one of the big issues that we see is people will create the living trust, they'll spend the money, get the documents drafted, and then they never fund it. They never put anything into it, and it's useless. Because then all this other stuff, it's going to go via the beneficiary designation, or it's going to go through probate or intestacy or whatever. So do you need a living trust? I mean, they're pitched all the time. I would say probably most people could use a living trust. And it's not because of probate avoidance, because most of your assets are going to pass outside of probate anyway. It's your 401k and your home when it's jointly titled, all that kind of stuff. It's not going through probate anyway. Where the trust really becomes important is that stuff I was talking about. It's like protecting it from your kids' bad habits and divorces and bankruptcies. It's to hold funds in trust for minors. You can use those incentive provisions to kind of pass along family values. If you've got special needs kids or grandkids, you can put it into a special needs trust and have it used for certain purposes and make sure they're taken care of. I think they're very important when you've got second marriages or blended families. They're super easy to change and amend. So the downside, and the reason a lot of people don't do them, is it costs more to do a trust than it does a will. So you have higher upfront costs, but certainly lower costs at death because you don't have any costs at death. And if estate or inheritance tax is an issue, having a properly designed trust is critical. So I think the trust is valuable, not so much because of the probate avoidance. I think that's overblown. It's these other issues that I think, require having a trust. So the will and the trust are going to control where everything goes when you pass away. But you've got a couple other critical documents, probably even more important, that impact what happens while you're alive. And so you have the financial power of attorney, and then you have your healthcare power of attorney. So the financial power of attorney allows you to transact your finances if you're incapacitated. So let's say, you're in the hospital and you're in a coma, or you have Alzheimer's or something like that. This financial power of attorney allows someone, your spouse or your kids, to take care of these things for you, to be able to pay your bills, to deposit funds or withdraw funds from your bank accounts, to change your investments, to buy and sell property, to take care of your pets, all of that kind of stuff. Again, whatever you have in the trust is not impacted by the financial power of attorney. The trustee manages those. But for everything that's outside of the trust, the financial power of attorney is a critical document. And there's two versions. the durable and the springing. What you typically have is what's called a springing power of attorney, which means it doesn't come into play until you're mentally incapacitated. And at that point, your doctor certify you're incapacitated, it becomes in effect, and now your power of attorney can take care of these for you. Sometimes you may have what's called a durable, meaning it's impacted already. So maybe you just want to have one of your kids be able to do these things for you because you're getting up in years, or you feel like, you know, maybe your mental capacity is slipping a little bit. So maybe you'd have a durable power of attorney in place automatically. The downside to having either one of these is that if you pick the wrong power holder, they could, and you know, there's plenty of horror stories out there where they could essentially steal stuff from you. And you know, you hear the stories about a caretaker or, you know, a family friend or something becoming the power holder, and they drain the bank accounts. So that's a risk. So you have to be really smart about who you're picking as your power holder. And you can limit the powers that they have in the document. But typically that's why you don't want a durable power of attorney unless it's really necessary. You typically want a springing power of attorney so that it's not becoming effective until you're incapacitated. And then the other one is the healthcare power of attorney or living will. And so what it does, it allows you to specify what you wanted to do or what you feel about things like life support. Do you want life support? Do you not want life support? Do you want to be kept on a feeding tube? Do you want to be given pain relief even if you're not on life support? You get to say what you want to have happen. And if you don't have this document, then the hospital or the state is going to decide. I think we can probably all remember that case in Florida, I can't remember the lady's name, where the husband and the family were fighting over this poor lady who was in a coma because she didn't have a healthcare power of attorney in place. The other thing the healthcare power of attorney does is where you specify whether you want to be an organ donor. And there you can say, I only want certain body parts. I only want it for medical use, not research use. You know, you specify that. And depending on the document, you can be very specific about what you want to happen in terms of, you know, the end of your life and life support and things like that. So again, these have nothing to do with how much money you have, how much wealth you have. Everybody who's an adult needs these. And so if your kids are now 18 years old, mom and dad don't get to say what's going to happen with these things anymore. They're adults. They need their own documents. And so, again, they can be very straightforward with the healthcare power of attorney. We've got a kind of fill-in-the-blank one we can use that if you need one, we can provide it to you. But everybody who's an adult needs to have these documents. Okay, so then what about beneficiary designations on your retirement plans and your life insurance, et cetera? If you're married, normally your spouse is going to be the primary beneficiary. As I mentioned before, if you know you're married and you pass away, your spouse can roll that into his or her own IRA. And why would we want to do that? Well, let's say you're only 65 years old. You don't have to take those required minimum distributions until the spouse who rolls it over turns 72. Where if that spouse is 65 and we leave it in the name of the deceased spouse, they have to start taking those RMDs right away. And so, you know, we always have to look at that. If we leave it in the name of the surviving spouse, or I mean, if we leave it in the name of the deceased spouse, then the 10% penalty doesn't apply. So we don't automatically always want to roll it over. Let's say we've got a client who's, you know, passed away at 50, and the surviving spouse is going to need this money to live off of. If we roll it to her own IRA, now she has to wait, or he has to wait till 59 and a half to take the money out without penalty. If we leave it in the deceased spouse's IRA, and you have now what's called an inherited IRA, we can pull that money out without the 10% penalty. So we have to evaluate that. What's the best option? But we can determine that by having the spouse be the beneficiary in either case, and then we can decide which way we want to do. Or maybe it's a combination of a couple of those items. Now, if you're single We just have to kind of look at your circumstance and say, okay, do you want it to go in the trust because we don't want the beneficiaries to get it right away? Or, you know, hey, they're old enough, they're responsible, they can just take it right away. In that case, we can just make those beneficiaries, you know, those kids or whatever, the beneficiaries directly, and we don't have to have it go to the trust. What's really important to note, though, is that beneficiary designation controls. So let's say you have a life insurance policy you bought 20 years ago, and you're on your second marriage and you never updated the beneficiary. When you pass away, whoever that beneficiary is, say the first spouse, is going to get that money. So it's critical, and it works the same way with a retirement plan. That beneficiary designation controls, and the will doesn't affect it, the trust doesn't affect it, the fact that you remarried doesn't affect it. So we have to make sure that the beneficiary designations are always up to date. Okay, so now let's talk about some of the estate planning mistakes and then some smart things to do, and then we'll open it up for questions. The big one is not having a plan in place. It's amazing how many people we see come in the door that we're doing financial planning for that haven't addressed estate plans. In fact, 6 out of 10 Americans don't have one. Why? A, it could be the cost. You know, people know that it's expensive to go to an attorney and get documents. And B, a lot of times it's just nobody wants to deal with that topic, or they don't know who they'd leave their assets to, like my friend Bill. Or maybe, you know, it's a married couple and they can't come to agreement on how they want to split everything up. So it's delayed. But this is the biggest mistake you can make, is not having a plan in place and not having those documents. Other things we see, as I mentioned, a lot of people, they'll go to the living trust seminar by an attorney, they'll get fired up, they'll buy the document package, they'll get their living trust, and they don't put a thing in it. And so it's an absolute waste of money, because at that point it's just a piece of paper. So if you're going to get a living trust, step 2, and it's critical, is to make sure we fund it. Everything that we want to keep out of the probate process needs to go into that living trust. And so we've got to make sure that it gets funded. The titles get changed, and beneficiaries get updated to the trust, things like that. The next biggest mistake are outdated documents. See it all the time, that you did the right thing, you went and got these documents, but they're 20 years old. And as I mentioned, 20 years ago, the estate tax exemption was $600,000. So almost every trust had these estate tax avoidance provisions in them. Well, today the exemption's almost $12 million. And so those estate tax provisions that are built in the trust are outdated, and they can actually work against you. And we see that all the time. I could take a look at a trust document and tell you in 5 minutes whether you need to revise it or not. The other thing we see are deceased or out-of-date executors or guardians. Again, you get married, you have your first kids, and so you name your parents or a brother or something as the executor of the estate. Now it's 20, 30 years later, that person's deceased or they're too old to do it. We have to make sure those things are up to date. And then I just talked about the outdated beneficiaries. The beneficiaries passed away, or you remarried, or you've gotten divorced, or whatever it is. We've got to make sure those beneficiaries are up to date, because the last thing you want to do is have this life insurance policy you've been paying on all these years and find out it's going to go to your ex-wife. And then finally, keeping documents in your safe deposit box. A lot of people, they would do that. They'd go get these documents. They'd put them in the safe deposit box at the bank. Well, what happens is when you pass away, those get sealed. And then you've got to get the letters testamentary and all that kind of stuff. So you don't want to keep, you keep a copy in there, but you don't want to have the only documents in that safe deposit box. So what are some smart things you can do? Review the documents and the beneficiaries every year. Yep, most of the time when we're doing this for clients, it's like, hey, everything's still okay. We don't need to do anything, but we need to at least be looking at it every year. Has anything changed? Do we need to update your disposition schedule in your trust? Because you sold the boat or the motorhome or whatever, or you bought something else. So we've got to make sure all those are updated. The other thing you want to do is to store your documents digitally. if you have a financial plan with us, we have the document vault in your financial plan where you can store copies so that, God forbid something happens to you, your heirs could contact us. We've got all the documents. We can help them guide through the process. So having digital copies stored in, the vault in your financial plan or some other secure place is a smart thing. Having an up-to-date asset and liability list. So if something happens, your kids or grandkids or whomever, or your spouse even, knows what everything is. Because a lot of times, in most families, I'd say one spouse handles all the financial stuff and the other one is not that involved in it. And we've seen it many times where one of them passes away and the other one has no idea what everything is or where it is. And so having that asset list, either for your surviving spouse or for your heirs, is critical. The other thing that's kind of new, but it's critical too, is all your digital asset logins. So if something happens to you, who's going to go in and turn off Facebook? And, maybe you've got, airline miles or whatever it is, Bitcoin. Someone needs to know how to access this stuff. So you need to have, as part of that asset and liability list, a list of all your digital asset logins. And each company has their own rules about how they'll turn things off or who they'll let turn things off. But you need to include it in the estate plan these days. It's just a big part of it. And then letting your heirs know about your plan. I know sometimes this is a touchy subject. Some people, they don't want their kids to be involved in their finances. But I think you'll find that it actually makes it a lot easier on everybody if your kids do at least know what your intentions are and the plan is, so that there's not a lot of squabbling when you pass away and all of a sudden some things are sprung on people. It can cause a lot of hard feelings. And so part of that is consider having a family meeting. If you've got a blended family, you've got a lot of heirs, and you've got some significant wealth, having a meeting with everybody and walking through, okay, this is our plan. This is who's going to get what. This is who our trustee is. These are where our documents are located. All of that is a good idea. And we can facilitate those for you. And then obviously if you have a business, you've got to plan for the succession of the business. That's another one of those mistakes that we see is, everybody's just so driven about growing their business, and then something happens, you pass away, you become disabled, and all of a sudden the business grinds to a halt, and maybe there's a spouse who's relying on that income that can't run the business. So we have to work on business succession planning as well as part of the estate plan. Okay, and then kind of the last thing to talk about is we've got to work tax planning in with the estate plan. So what can we do so that, your heirs receive everything in the most tax efficient manner? And so sometimes that means doing Roth IRA conversions, because as I mentioned before, if you have a regular IRA or 401k, your heirs get to pay the income tax when they take the money out. If they inherit a Roth IRA, there's no income tax. Yes, they have to take minimum distributions, but it's tax-free, so who cares? We have to look at things like, one of you, a married couple, one of them passes away. Do we do a spousal rollover, or do we do the inherited IRA? If we do the inherited IRA and we need money prior to 59.5, there's no 10% penalty. If we roll it all over to the spousal IRA, we don't have to take it out till 72. But if we need it before 59.5, we have to pay the 10% penalty. So we have to evaluate, what's the route there, and we can combine both of those. You also have what's called a stretch IRA. The rules just changed on this. Before, if, let's say you passed away and passed down your IRA to, a 50-year-old child, that child could stretch it out over their life expectancy, which might be 20 or 30 years. Now the rule has changed where the maximum you can stretch it out is 10 years. But still, we evaluate, does it make sense to take it all out in 1 year and all of a sudden throw yourself into the 40% tax bracket, or you throw in the California's 13.3 or whatever, now you're 50% plus. Maybe we'd be better off stretching that out over those 10 years and spreading the tax. Sometimes we have to look at gifting. gifting things down to someone who's in a lower tax bracket and have them pay the income tax. Or a technique I've used a couple times now is what we call an upstream gift, where I'll give you an example. I have a client who he bought Apple at, I believe it was $22 a share, and he owned a substantial amount of Apple. He had a 93-year-old mother who was in great health. And so what we did is we gave his mom some of the Apple shares. So she got the dividend, but we set up a transfer and death account so that when she passed away, it would go back to my client. So she passed away January of last year, when I believe the value of the stock was over $200 a share. So now we just moved his basis from $22 a share to $200 a share. We were able to sell it without the capital gains tax, and he re-inherited the money. So we've got things we can do like that if they fit into your particular situation. And then finally, if you're going to do things with charity, we always have to look at what can we do from a charity standpoint to save taxes. And let me give you an example here of how this works. So let's say John has two assets. We got an IRA worth $100,000, and we've got a stock portfolio worth $100,000. This is what we would see all the time: half to charity, half to the kids. The kids typically would be named the beneficiary of the IRA, and then charity would get the stock through the will. Well, what happens in that scenario? As I mentioned a couple times, the kids get to pay that IRD tax. So let's say a combined tax rate in California is 30%. So they don't net 100, they net 70. And Uncle Sam inherits 30,000. Now charity gets the stock. Charity's tax exempt. They don't pay tax anyway. So they net the $100,000. So we didn't accomplish what we wanted to accomplish. And there's a simple fix to this. Having the right asset go to the right person makes all the difference in the world. What I typically call, you want to give the good assets to your kids and the bad assets to charity. So let's just reverse it. Let's say, okay, now the kids are going to inherit the stock. Well, they get that stepped up cost basis I talked about. So now they net all $100,000 if they sell the stock, because they didn't have to pay the capital gains. Charity is the beneficiary of the IRA. They inherit the IRA. They're tax exempt. So they don't have to pay any tax either. So they get all $100,000. The only person we cut out of this equation is Uncle Sam. And all we simply did was give the good assets to the kids and the bad assets to charity. But it's things like this that we always have to look at to see what can we do to maximize that inheritance for your kids. And honestly, with the estate tax exemptions the way they are today, the bulk of that is going to be income tax planning. What can we do to save taxes? That's kind of our motto at Anchor Bay. It's not what you make, it's what you keep. And so we're always looking at that. So then how do we work in terms of estate planning? We can do a bunch of things for you. First and foremost, if you don't have your documents, or they're just so out of date they just need to be scrapped, we can help you get your documents prepared. And we go a couple different routes. If it's a complicated situation, like a second marriage or a blended family or special needs, you're probably going to have to go to an attorney and bite the bullet and spend a couple $1,000s to get the documents done. If it's fairly straightforward, it's kind of the I love you will or trust, then we use a online service similar to LegalZoom called Helios, where we actually go through the process online with you to get your documents done. And they spin them out in a couple days, send them to you. And they charge a flat fee. It's $450 for the documents, the will, the trust, the power of attorney, all of that. And then if you have to transfer titles to deeds for real estate, they charge you separately. That might be another $300 or something. But I just have a hard time sending our clients to one of the attorneys we work with that have to spend a couple $1,000 to fill in blanks on boilerplate documents when the planning's pretty straightforward. And so then that's why we have the relationship with Helios is we'd rather have you spend $600 or $700 and get all your documents and get it done. We certainly help with estate plan reviews, reviewing your documents and making sure beneficiaries are up to date, all of that. We do estate administration. So if you have someone who passes away, we can help you go through the process. We can prepare the estate tax returns, the trust tax returns, the individual tax returns. As I mentioned, as part of your financial plan, you have the document vault, so you can store copies. We'll do those estate planning meetings for you. So if you wanted to get your family together, we can walk them through the estate plan. It's, you know, it's an impartial person. We can act kind of as a, you know, the mediator there. And having that family meeting, I think, eliminates a lot of conflict on the back end. Now, you may not be here to be involved in it, but we see it all the time. It's like all of a sudden everybody's at their, you know, each other's throats because one person got, you know, this china and another person didn't get the family photos or whatever. So those estate planning meetings where you're going to lay out everything and talk it through, I think are very helpful. And then finally, you know, we can do estate tax and charitable tax planning where it fits. We certainly have the expertise to help minimize estate taxes and income taxes through charitable tax planning. So we can pretty much help you with whatever you need in terms of estate planning services. Often it's all included in our financial planning fee. Some things like the document services obviously would be a separate fee, or maybe preparing an estate income tax return or something. But most of the time, this is all just included in your financial planning fee. So if you're a financial planning client, we're going to do these things for you with no additional charge.